Good morning, everyone. Good morning, Instagram, Facebook, YouTube. Hope everyone is doing well. I have a good topic for you guys today. Just let me put in my phone number real quick. Good morning. Welcome. Come on in. Sorry, guys, I'm just typing in my phone number and Instagram. Okay, let me pin it. Okay, so good morning, everyone. Hope you guys are doing well. My name is Ayesha Chidolwe, and I'm an immigration attorney here in Atlanta, Florida. But we represent clients in their immigration matters in all 50 states. We handle family-based immigration, humanitarian-based cases, removal cases, which is deportation defense, some bond cases if you're detained. So we'll be happy to assist you. If you'd like to schedule a consult with us, our phone number is 678-325-1037, or you can also call 678-233-2170, or you can send a WhatsApp to 404-333-8751. All these numbers are in the profile, our link in the bio. You can also directly book your own consultation yourself through the link in the bio on Instagram, Facebook, YouTube, or whatever. Anyway, hope you guys are doing well. Welcome wherever you're tuning in from. If you're first timer, welcome. Today, I wanted to talk about basically what happens if your joint I-751 is denied and what options you have. So first of all, for those who don't know, what is an I-751? So typically, when you file for a green card for your spouse, I'm going to use spouse because it's easier to use the spouse here. If you have been married for less than 2 years at the time they approve your green card, you get a 2-year conditional green card. And when you get a 2-year conditional green card, before the 2-year expires or at the expiration, you want to file for what we call removal of conditions on that green card. So basically, you're asking them to remove the conditions on the green card and give you a 10-year legal permanent residency green card. And that application that you complete is called the I-751. So typically, when you file an I-751, you are supposed to file it with your spouse. You know, the spouse will help you to get your green card. And if something happens or whatever, let's say you go to the interview and they feel like you don't have a good faith marriage or you don't have evidence of good faith marriage, what typically happens is they deny you and they are required to place you in removal proceedings. Removal proceedings is the same thing as deportation proceedings. It means that they are required to send you to an immigration judge to make a determination if they are going to terminate your green card or not, or if you have any other basis to remain a green card holder. Now, is all lost if you are denied? No, it's not. There are a few things that we usually like to explore if you come to us based on a denied joint filing of an I-751. So the first thing we want to determine, first of all, is that are you eligible? So even if you were placed in removal proceedings, if we determine that you're eligible for another basis, meaning you're eligible to remove conditions based on a waiver of joint filing, either because, i.e., maybe your spouse is dead and passed away, that sounds so morbid, or you and your spouse are now divorced, or you have suffered extreme cruelty or abuse, or you will experience extreme hardship. If you fall into any of those other 4 categories, you can file a new application, a new I-751, which actually will reactivate your green card and allow you to get or continue using your green card even while your case is in removal proceedings, because USCIS has original jurisdiction. What it just means is basically have original authority to review I-751 applications. So if you file that new application, typically the judge will continue, which means pause the removal case to see what happens, with USCIS and the new filing. Understand that if you choose not to go that route of refiling, maybe you qualify for a new basis, the judge can only make a determination. And, some people may say, well, I'll just deal with it with the judge. Understand that the judge can only make a determination based on whatever you originally filed. So if you did a joint filing and your joint filing was denied and you're like, okay, let the judge decide it, the judge can only decide based on the joint filing. You can't at that time decide you want to add other waiver grounds like, okay, we're now divorced. The judge is only going to be making a decision on the joint filing. So when you're eligible for another basis, it's always good to, resubmit your I-751. I'm going to talk about the waivers in a second. And then also, if you are requesting a waiver, you can select all waivers that apply to you. So if more than one waiver applies to our clients, I prefer that we select all. Again, for the same reason that if a case is denied, we don't want a judge to decide only one basis. We want them to decide all bases. Let me give you an example of that. So for example, if someone comes to us and says, I'm a victim of abuse, my spouse has been very abusive to me. Also, I can't take it anymore. I've divorced my spouse or my spouse divorced me. So that becomes two bases of how you can remove conditions. So usually we want USCIS to make a decision on either of them. We start with the strongest and say, if you're not able to make a decision based on this, this is also another category. So in going through the waivers, and then same thing with extreme cruelty. And I'm going to talk about extreme cruelty a little bit just because it's not extreme cruelty, extreme hardship, because extreme hardship is actually very complex. A lot of people don't understand the requirement of extreme hardship and the timeline of extreme hardship in I-751 cases. But if you're ever able to get extreme hardship, which is like a unicorn because it's just so hard to get, anyway, I'll get into that in a second. So let's talk about the waiver. So of course, with the first waiver, which is based on extreme cruelty and, abuse, USCIS is looking for you to prove two things. The two things are going to be, one, that you were in a good faith, genuine marriage, regardless of what happened to you. So you cannot bypass that. You have to prove that you were in a good faith marriage and this was a genuine marriage. That's number one. The second thing is you have to prove that your spouse was extremely cruel to you or abusive to you. Understand that, unlike, say, a VAWA case where the standards are any credible evidence, meaning all the evidence that you're able to gather, there's more of a strict standard with a conditional green card when you're trying to allege abuse. Because in that case, it's, and this is my assessment of the analogy and why they've made it this way. When you're a green card holder, typically you already have a green card, you have a social security number, so there's no fear if you needed to call the cops. There's no fear if you needed to go to a therapist. There's no fear if you needed to go to a clergy or like a religious leader to guide, offer you therapy or guidance, or whatever the case may be, versus in a VAWA case where you don't have a green card and truly, so many, especially in 2026, are truly frightened to call the cops because even though somebody might be pounding them through the face and just so abusive to them, the fear that they don't have status stops so many people from contacting a police officer because of, what could potentially happen about their own status. That is a real plausible fear that so many people experience when they don't have it. But they feel like if you're a green card holder, some of that fear is not necessarily there in terms of I'm going to report and all of a sudden I'm going to be the one in trouble. All of a sudden I'm going to get deported. I mean, your spouse could threaten that, but you have a green card. And so, there's that expectation that you have to have a bit more evidence. So they're usually wanting to see a bit more. If it's not in the form of a police report, they're wanting to see psychological evaluations. They're wanting to see some sort of evidence, some sort of neighbors that know what's going on, some sort of therapy or counseling that you've done with, religious leader, or if you've been to the doctor or seen a physician, or like an evaluation. So they're typically going to want to see a little bit more, or your own evidence that you have. If you don't have all of that, then what evidence did you gather for yourself, that you can show USCIS? So that's typically what they're wanting to see. Now, if you're able to meet, show all of that, then you will be approved for a 10-year green card. And typically for people in that category, you are eligible to get your citizenship 3 years from the date of your original green card. So even though you end up divorced, or even though you end up filing like a waiver, but if you're approved for abuse, the time requirement was going to be 3 years from the original date of your 2-year green card for you to get citizenship. Now, if you're filing a waiver based on divorce, the only thing that you need to prove is that your marriage was genuine. Your marriage was genuine. Your marriage was in good faith. We just divorced because it just didn't work out. For whatever reason, you guys are no longer together, infidelity, irreconcilable difference, irretrievably broken, whatever the reason is, as long as you can prove that your marriage was genuine, then you'd be able to get your 10-year green card based on that. With that, you will not be eligible for citizenship until 5 years. Okay. And then now let's talk about extreme hardship, because again, this is one of the most complex areas, if you would. So basically, with extreme hardship, the most critical thing that they're looking for is that the hardship happened after the person became a conditional permanent resident. Let me repeat that again. If you are saying that you are going to suffer extreme hardship, that hardship that started or was created must have started when you became a 2-year green card holder. Like, there is no wiggle room around this. Okay, let me see how I can simplify it for you. Like, so for instance, if you say, oh, it was really hard for me in my country, this is what happened, like, I don't know, like you were running away from like your family trying to force you to marry someone. And if you go back there, like they're going to harm you. I'm just making up something. Like, that hardship is not usually enough. The hardship has to have occurred once you got your 2-year green card. So some examples of that are going to be, and the only time you can use a pre-existing situation is if it worsened or continued after you became a conditional green card holder. So for instance, let's say you had a medical condition, right? Before you got your green card, and you all of a sudden become a green card holder, and now maybe you now have that condition has like amplified, and you have medical documentation to prove that it's amplified, or that maybe you have cancer, God forbid, but let's just say, or something like, but this all happened after the 2-year conditional green card. That's going to be one example. And then, if you want to use country conditions, for instance, they're not going to consider country conditions before you become a green card holder. What they're going to look at is country conditions that became worse or intensified within the time that you were a green card holder. So let's say you're from a country that's has had a lot of issues, and for whatever reason, when you became a 2-year green card holder, it amplified to war, or like documented killing of let's say you're Christian. Let me use that because that's one of the more popular ones. Like, if you're from a country where there's like a mass killing of Christians in wherever region you're from, and you're able to show that all of this amplified, for instance, when you became a 2-year green card holder. Those are some things that you can make. And then also, not only hardship to yourself, you can also show hardship to, let's say, your children. Like, for instance, you had a child after you became a 2-year green card holder, and your child has a medical condition, a heart condition, a condition that basically requires them to get constant help. They need to go to see the doctor often, where it is extremely or extraordinarily hard to tell that person to be flying here or leave your child here, because obviously if you had a child within those 2 years, that means the child is like an infant. So like that would be extreme hardship, or, severe psychological conditions that developed, after the 2-year green card, or extraordinary financial consequences that's kind of tied to the applicant. But again, these things have to have occurred after you became a 2-year green card holder. So those are some things that they would consider. The one thing when you are doing extreme hardship that they don't consider is good faith marriage. So it's not one of the things that is considered. All they're looking at is, do you have extreme hardship? And did your extreme hardship start after you became a 2-year conditional green card holder? So again, these are some waivers that you would have available to you if you qualify, if your I-751 was denied because you did a joint filing, or if you are in that situation and your spouse refuses to do an I-751 with you. If you're eligible for any of these waivers, then you can use any of those waivers as well. So, even though you are placed in removal proceedings, typically once the 751 is denied, being placed in removal proceedings does not automatically mean deportation. It doesn't automatically mean that you will not be able to get an info pass to extend your green card while they're trying to determine another basis that you're eligible for. Okay, so let me take some questions from you guys. Okay, someone is asking, my I-130 got approved last year. She's in Jamaica. Does this have anything to do with this? I don't know the question you're asking, so I'm not able to answer that. Sorry. Your videos are always so informative. I have a question. Is it still possible to get an I-751 interview waived? I had my I-485 interview waived, and we just filed an I-751 in February this year. It is still possible, but I will say that we don't see as much waived. And if you didn't have an interview for your I-485, you should fully expect to have an interview for your I-751. Unless, like the cases where we see waived, there's absolutely unequivocally no single question. Like these applications are like filled and robust with, evidence of good faith marriage, children and all of that stuff, or just overwhelming evidence of abuse, overwhelming evidence of all these things. Those are the cases that we'll see that get waived. And typically for most of them, they had an interview during their marriage-based case. But again, if you were one of those who had your cases waived anywhere from those 2022 to 2024, you should fully prepare that you will have another interview. As a matter of fact, I have been in interviews with officers saying to my I-751 clients, your interview was waived, so we need to know if that was even a mistake. Like, should they even have approved your green card in the first place? So I'm going to be kind of interviewing for even that as well. So this happens. So expect that. If you end up not getting an interview, wonderful, but you should fully expect that you might be scheduled for an interview. Okay. Okay. I applied for VAWA in 2025. It's been a year. I just got my prima facie determination, and I completed my fingerprints. Can you please tell me, ma'am, how long does it take to get a work permit and social security number? Well, the answer is going to depend on if you file an adjustment of status application with an I-765 in the right category. Assuming you filed in the right category, which I don't know because I didn't file, I don't know what your application looks like. Then right now we're seeing anywhere from 9 to 11 months on average, for you to get those. And again, when they approve you for your work permit, you will most likely need to go to the Social Security office to pick up your Social Security card. The only group of people that we're seeing their Social Security card being sent to us, to our office now with the new administration, are going to be people who have their green card approved or who have their citizenship approved. If you have your citizenship approved, you basically, USCIS will update Social Security, so they can give you an updated one with no conditions on it. Depending on if you were a conditional green card holder that did like a double filing. If you're a green card holder, your 485 down gives you the, well, it's been giving you that since like, I think a year and a half ago, like, or 2024. You have the option there to select Social Security card once your green card is approved. So, but otherwise, the others will have to go to the Social Security office to pick it up. No, we don't handle J1 hardship waivers, unfortunately. Okay. Let's see. Okay, this person is like spamming me, so I'm just trying to get like the real questions that you guys have. Okay, when you type, I have a question, please. You can just type the question, and if I can answer, I'll answer it. I can answer it. I have a master hearing with Judge Jonathan Rangold in New York. Do you think when the judge is going to make an individual hearing date? No, nobody is able to answer that question. Only a judge can. I don't know what it is that what you have that's viable for you to stay here, because it's going to depend on that. It's going to depend on if you have a pending case already. It's going to depend on if you're trying to adjust your status in court. So all of those things, there are just so many variables, but no one can predict when an individual hearing will be. Only the judge's calendar dictates that. Like, this is not one of those things where there's a published timeline. It's based on the judge, that particular judge's calendar, and when they can fit you in. So you'll find out after the hearing, but good luck with your master's hearing. Okay, I have my VAWA approved last year, June. I got my biometrics this year. So what would you suggest next? Well, the answer is going to depend on whether you filed an adjustment of status with your application or not. If you filed an adjustment of status with your application, that should be what's coming next. Either an interview for the 485 or an approval on the 485. Okumaze says, good morning, Aisha. Thank you for all your great work educating us. Oh, you're welcome. Okay. Can my wife file a petition for me? The answer is going to depend on, one, what is your wife's status? Is she a U.S. citizen? If she's a U.S. citizen, sure, she can file a petition for you, which is a petition for alien relative. But the kind of petition she can file is going to depend on whether or not you live in the United States or you live outside of the United States. All right. Okay, I'll take one more question and I got to jump off. I submitted my application with my documents and I got an RFE asking for the same documents. Is that normal? Sadly, that has become a norm right now. Like, I don't know what is going on with USCIS. USCIS, if you guys are listening, please have the people in the file room get it together. Like, sometimes we'll submit everything and and then the RFEs come back and I'm like, are they missing some of the documents? Because these things on the list, we submitted them already. Well, so we're definitely seeing that happen, which is very annoying, but make sure you submit it with that and, remind them that you send it. Like for us, when we send back those responses, we attach those originals and show them exactly where they were in the original file that we sent them, because it is very annoying, to keep getting those after you send everything that they've asked for. Anyway, I hope you guys have a great day. I have to jump off. If you want to schedule a consultation, again, you can call our office, 678-325-1037. And also you can book it directly yourself. I hope you guys have a great day. All right. Bye.